Help! My Social Security claim has been denied by a judge, and I think they made a mistake because the judge ignored what my doctor has to say about my exertional limitations. What should I do? Hey, listen, as a Social Security disability attorney, I know that it can be tough to get a denial decision of your Social Security claim. You've waited years to get in front of the judge, and now you've got an unfavorable decision. I wouldn't necessarily give up quite yet. There's still some hope. One of your options is to appeal this denial to the Appeals Council. And the way that we go about doing that is to identify whether there are legal errors that the judge made in denying your benefits. What we want the court to do is to agree that there was legal error, remand the case, and send it back to the Social Security judge for another bite at the apple. Now, I find that one of the key reasons that cases get remanded is because the judge ignored or improperly blew off your doctor's opinions about your exertional limitations. What are exertional limitations? Well, exertional limitations are just that: your ability to sit, stand, stoop, walk, stoop, bend, lift, your ability to engage in bilateral manipulation of things, postural limitations. These are the kinds of things that are important because ultimately at step 4, the Social Security judge has to determine whether you can go back to the lightest job you held in the 5 years before your claim was denied. And at step 5, which is where most of these cases are won and lost, whether there is other work in the mythical, hypothetical, not real world national economy that you could do in view of your age, your education, and your restrictions. So we want to go about documenting exertional limitations. You won't find that generally in a doctor's report. So we Social Security lawyers have developed forms called residual functional capacity forms. We have them for about 70 different medical conditions. And hopefully your lawyer has asked your doctor to complete a residual functional capacity form, and your doctor has agreed to do that because you want to be able to present to the judge evidence of what those exertional limitations are. So for example, if you can only lift 10 pounds and stand 4 out of 6 hours, but you worked as a police officer standing all day dealing with suspects and chasing down criminals, pretty clear why you can't do your past work. But the ultimate question is there other work that you could do? And many times in a Social Security case, the judge will give a hypothetical to a vocational evaluator about your physical capacities and ask them whether there is other work. Many times VEs will come up with stupid jobs, like you could be an addresser, you could be a surveillance system monitor looking at a camera all day, or you could sort nuts and bolts. The best way to try to defend that kind of opinion at step 5 is to have that residual functional capacity form that addresses your exertional levels. Because I, as a Social Security lawyer, want to amend that hypothetical to the VE and try to get them to the point where they'll say that there is no other work. Having your doctor comment on those restrictions and limitations is key. And if the judge ignores those opinions, blows them off, or doesn't give them appropriate weight, that potentially can be the grounds for an appeal to the Appeals Council and ultimately a remand. If you have any questions about your rights to Social Security disability benefits, give us a call today at 727-894-3188.